This WPS.
Yes. This was
May not be
Serial
taken.
number?
Just find the next.
serial 4.
4.
Ramchandra Roja. Give your please.
From supplementary list of understood item 1, second appeal 58 of 1991 along with item 2.
Take points. Certified. कल जो आपने चार्ट बताया था, जो आपके नाम से रेंट रिसीप्ट जो इशू हुआ,
हाँ
एग्जिबिट
Exhibit
E
E
by 1, E and E by 1, उसमें प्लॉट नंबर 254 कहाँ है? आपके प्लॉट नंबर 254 का जिक्र नहीं है उसमें। बहुत देर तक हम खोज रहे थे, तो समझ नहीं आया, बट एक प्लॉट नंबर 254 है उसमें। जिस पे घर बना हुआ है। ये सुओमोटो केस नंबर 5 में खाता नंबर 120 में 254 तो नहीं है? चेक करिए इसको। एग्जिबिट ई।
स्टील लैंड कि स्टील लैंड पर अलग से किया होगा, इसमें तो ये नहीं है।
एग्जिबिट में नहीं है इसमें।
हाँ, ये नहीं है।
The suit was filed. Seeking a declaration and adjudication that the lands owned and possessed by the plaintiffs and their title and possession is not affected by any order passed by the revenue courts. The plaintiffs also sought confirmation of possession with respect to the suit property. The suit property was mentioned in the schedule to the deed and is situated at village Bhavandi, PS Channel, District Palam. The suit property is in khata number 88, 89, 116, 120, 121, 121, 121 and 122. The schedule of the plaint has already been stated above. So far as the substantial question of law framed in essay number 58 of 1991 within bracket R is concerned, the same is related to khata number 88 and 89. And with respect to substantial question of law number 69 of 1991 within bracket R, the same is relatable to khata number 116, 120, 121 and 122. And thereby the two substantial questions of law cover the entire suit property. In essay number 58 of 1991, the defendants are the appellants.
Yes.
Raghuvansh Narayan.
Yes.
The defendants are the appellants. The contesting defendants are the appellants.
Appellants.
And in essay number 69 of 1991, the plaintiffs are the appellants.
Appellants.
आप लोग को दूसरा में थोड़ा सा आज मत जाइए
नहीं हम नहीं जाएंगे
क्योंकि इसको खत्म करना बहुत कॉम्प्लिकेटेड फैक्ट्स है ठीक है इसको लिखाएंगे
जी
I don't think that I will be able to take up any case in the first half. नहीं होगा. This will take quite some time. तो 11 बजाए 1-1.5 घंटा मतलब 12:30 बजे के पहले आप लोग का कोई भी दूसरा मैटर so you are free till 12. It is an undisputed fact on record that pro forma defendant number 4 was ex-intermediary of village Bhavani and was allotted a separate takta bearing number 4 in partition suit number 24 of 1930. The takta included, inter alia included the properties which are the suit properties,
subject matter of the suit.
which are subject matter of the suit. It was the specific case of the plaintiffs that pro forma defendant number 4 remained in possession of the suit property. Which was her Bakast land and was in Khas possession. She had also constructed a house in the portion of plot number 254, which formed a part of the suit property.
No.
It was their specific case that they had fined Form K, the defendant of fined Form K for assessment of rent under Bihar Land Reforms Act.
That is exhibit 4.
Within bracket exhibit 4
Return file हुआ है. Return file हुआ है exhibit 4.
Form K
फॉर्म के फाइलें नहीं हुआ. ऑर्डर स्टेटमेंट तो आया है फॉर्म के. लैंड पे आके फाइल किया लेकिन फाइल किया नहीं.
ठीक है, प्लेट में है ना,
हाँ लैंड.
प्लेट में है ना,
ये भी बोल रहे हैं फॉर्म के फाइल हुआ है.
ठीक
डब्ल्यूएस में लिखे हैं
डब्ल्यूएस में अपना बोल रहा है
फॉर्म के फाइल हुआ है. There are 16 में लिखे हैं.
just जो इनका केस है पहले वही लिख रहे हैं. However, no rent was assessed.
Yes.
The
इसमें
Bihar Land Reforms Act came into force on
in the year 1950.
date है ना specific.
55. बता.
Twenty-six 1/1955. However, the plaintiff sold the entire school property to the, however, the pro forma defendant number 4 sold the entire school property to the plaintiff by registered sale deed dated 15/9/1962. The plaintiffs claimed that they were put in possession of the property and thereafter they applied for mutation. As the plaintiffs were under the impression that the assessment of rent must have been made in course of time. However, when they came to know, when no further intimation was received in connection with case number 275 of 1962-63, they filed another petition in the year 1970, which was registered as mutation case number 354 of 1970-71, 345 of 1970-71, and at that point of time, the plaintiffs came to know that the principal defendants have got the rent of the land assessed in their name. Consequently, there were were already assessed in their name in AR case number 5 and 6 of 1961-62.
AR case number 1168 of 55-56 and AR case number 1169 55-56.
ये तो आपका पेज में लिखा हुआ AR केस नंबर 5 and 6.
कि हमारा किस लिखा है
इनका केस लिखा हुआ है.
आपका किस नहीं है सर हमारा किस
In AR case number 5 and 6 of 1961-62.
in the name of principal defendants
In the name of the principal defendants. It was the case of the plaintiffs that the principal defendant neither filed any return under section 3B nor filed any application in form K, and there was no occasion for assessment of rent in the favor of the principal defendants. And therefore, it was a case of the plaintiffs that the assessment of rent in the name of principal defendants was without any basis and was void ab initio.
and
However, when the circle officer refused to assess rent in favor of the plaintiffs on the ground that the rent was already assessed and standing in the name of the principal defendants,
in sumo motu proceeding
in the name of the principal defendants, the plaintiffs filed appeal in connection with the order passed in mutation case number 345 of 1970-71, which was, but the appeal was also dismissed on 17/9/1971. And ultimately, the plaintiffs had no option but to file the suit for the opposition. The contesting defendant number 1 and 3 and pro forma defendant number 4. They filed different written statements. The H is on. the contesting dependents in the written statement asserted that pro forma dependent number 4 was never in possession of the suit property and was a widow prior to 1922. And her son also died at an early age. And ultimately, pro forma dependent number 4 left the village and settled in another village called Daga. It was their specific case that the contesting dependents were in possession of the suit property right from the year 1930. And they remained in possession to the knowledge of the plaintiffs and also to the knowledge of the pro forma dependent number 4. And they also asserted that the contesting defendants had also filed return and form K the contesting defendants asserted that the return and form K alleged to have been filed by pro forma dependent number 4 if filed before the revenue authority would have led to assessment of rent in terms of section 5, 6 and 7 of the Bihar Land Reforms Act. However, pro forma defendant having no possession over the property on the date of vesting, that is on 26/1/1955, there was no occasion to assess rent in effect. It was their specific case that the rent was assessed in their favor in case number Roman 5 of 1961-62 and also in case number Roman 6 of 1961-62 and further in case number 1168 of 1955-56 and 1169 of 1955-56.
ये suo motu case होता है.
Yes. Suo motu case.
Suo motu.
ARA मतलब
assessment of rent.
assessment of rent.
Assessment.
In AR case number 1168 of 1955-56 and 1169 of 1955-56. And the order was passed in favor of the contesting defendants. And the state also realized rent right from nineteen 1955-56 from the principal dependents.
1955-56 में सिर्फ खाता नंबर 18 और प्लॉट नंबर 667 का असेसमेंट हुआ है 55-56 में.
हाँ, एक सेकंड. However, it is not in dispute that the case number 19 or in case number 1169 of 1955-56 and case number 1168 of 1955-56 was in relation to खाता number 89,
प्लॉट नंबर
plot number
667.
कल तो आपने बताया नहीं. And so far as the other lands are concerned, they were covered. Reverse it time. They also asserted that Karamchari of the circle had submitted a report in mutation case number 345 of 7071 for fixation of rent in favor of the plaintiffs, but upon objection by the principal defendants, the prayer seeking mutation was rejected by the order dated 29/1971 by the circle officer, against which the appeal was also dismissed on 17/9/1970. It was specifically asserted that with respect to house standing on plot number 254, the same was constructed by the principal defendants and it was specifically asserted in paragraph 31 of the plaint that defendant number 4 was ousted from the village way back in 1930 and she never returned in the village and therefore question of her possession with respect to the suit property does not arise. The case of the defendant number 4, pro forma defendant number 4 was that she remained in possession of the suit property pursuant to, remained in exclusive possession of the suit property pursuant to allotment of property in the title suit, in the partition suit number 24 of 1930. She had filed Form K for assessment of rent and was peacefully cultivating the land prior to its transfer made in favor of the plaintiffs by registered deed. And she had also constructed one house in plot number 254, which was ultimately transferred in favor of the plaintiffs, in which the plaintiffs were residing. The case of the contesting defendant number 1 to 3, that pro forma defendant number 4 was ousted from the village since 1930 and that she had not returned to the village, was specifically denied. It was asserted by pro forma defendant number 4 that she always remained in village Bhavandi and got the cultivation without any interference from the pro forma from the principal defendant number 1 to 3 and their predecessor in interest. It was asserted that Sukhdev Rampan father-in-law. There is another sale deed also. It was asserted that the principal dependents have no concern with the land of the pro forma dependent, and that pro forma dependent was a widow having religious temperament, but by that it did not mean that she could not transfer the property to the plaintiffs. The suit was the following issues were framed by the learned trial court.
Para
And the issue number, इसको quote करने के बाद, issue number 4, 5 and 7 were taken up by the learned trial court together. The learned trial court recorded the aforesaid admitted facts in paragraph 9, A and B of the judgment. The last sentence of the The learned trial court recorded that admittedly dependent number 4 was the vendor of the plaintiff, and the defendant number 4 had title and possession over the suit land till 1930, and consequently the onus was on the principal defendant to establish their title and possession over the suit land. It was also observed that DW13 in his evidence has stated in cross-examination that the suit land was their ancestral property and they had acquired it from pro forma dependent number 4 by oral gift
in the year 1930.
However,
किस तरह से तकरारी जमीन हमारा मनुष्य जैसा है, पशुमा जन्नतराज कुमार ने जमीन मौखिक रूप से हमें देकर
by oral gift.
Oral gift.
And the court recorded that there was no doubt that pro forma defendant number 4 had title and possession over the suit land. Thereafter, the learned trial court observed that the defendant, that the Principal defendant also claimed right title by way of adverse possession. And further observed that it was to be examined as to whether the principal defendant had continuous and hostile possession against the pro forma defendant number 4 for more than 12 years from the date of filing of the suit. The learned trial court then considered the materials and observed that the defendants failed to adduce a chit of document from 1930 to 1955 regarding their title and possession of the district land. And further observed that defendant number 3 in his cross-examination admitted that he had obtained the property from the pro forma defendant number 4 in the year 1930 on the basis of oral gift, but there was no documentary evidence with respect to the oral gift. It was also observed that the defendants had stated that they had filed zamindari return K form showing their land in their khas possession, but no such document was produced before the court. The court then went on to observe that the plaintiffs filed and proved zamindari return exhibit 4 showing that pro forma defendant number 4 had shown plot number 210-254, 601, 665, 667, 668 and 293 in her khas possession. However, in column 13 of the zamindari return, she had indicated that the property in disputed khata number 160, 120, 121 and 122 were in possession of Rayyan. The court further observed that so far as these Rayati khatas are concerned, the case of the plaintiffs was that the defendant number 4 had not stated as to when the Rayats had abandoned the village. The court also observed that the defendant, the principal defendant had failed to adduce any evidence on the point of abandonment. The court also observed that the plaintiff failed to adduce any evidence on the point of abandonment, but the defendant number 3 had admitted in his examination that defendant number 4 was in possession of these lands. The court ultimately held that it could be safely held that defendant number 4 was in possession of the suit land at the time of the stay. Thus, the trial court returned a specific finding that the defendant number 4 was in possession of the suit property at the time of the stay.
If observation or if this would permit below. The plot number 210, 601, 144, 251, 623, 749 and 249 are concerned. Rent of these plots were fixed in the name of defendant on suo motu basis.
अभी तो हम फाइंडिंग लिखा रहे हैं ट्रायल कोर्ट का। आज वी कम टू द फाइंडिंग।
ट्रायल कोर्ट का ही फाइंडिंग बता रहे हैं। ट्रायल कोर्ट का ही फाइंडिंग में
कहाँ पर है? पैरा 12
का पेज 10 में लॉर्डशिप देखते हैं। इसमें
अभी पैरा 5 में।
अच्छा जी।
बेस्ड इन दी। The learned trial court then considered the assessment order and the rent receipts of the principal defendant and observed that in case number 5 and case number 6 of 1961-62 and ये suo motu तो 1168 का नहीं था, suo motu 1168 का नहीं था. In case number 5 and 6 of 1961-62 and in suo motu case number 5 and 6 of 1961-62 and case number 1168 and 1169 of 55-56, the rent was assessed in the name of the defendants and the state government granted rent receipt within the knowledge to the defendants within the knowledge of the pro forma defendant number 4 and also within the knowledge of the plaintiff. The learned court ultimately held that admittedly the defendants are paying rent since 1955 and the plaintiffs or the pro forma defendant number 4, if they had any right that was extinguished by way of adverse possession. The learned trial court then observed that from perusal of the order of assessment case number 1168 and 1169 of 1955-56, exhibit D and D/1, it was clear that the land of plot number 667 was only assessed through AR case. So far as plot number 210, 601, 144, 251, 623, 749 and 251 are concerned, the rent of these plots were fixed in the name of the principal dependents on suo motu basis. The court posed a question that if the defendant had filed a return informed plea at the time of vesting, why the rent was fixed only in connection with plot number 667 in the year 1955-56 in the AR cases. And why at that point of time the rent was not assessed in connection with other plot numbers. The learned court also observed that the defendants failed to prove a kit of paper regarding their possession of a plot number 254 and observed that the defendants have no documentary evidence of possession except the rent receipts relating to CCDs. आपके पास इसका रेंट रिसीट भी नहीं है 254 का,
उसका नहीं है।
आप चेक कर लीजिए, नहीं
मेरे पास नहीं है।
आप चेक करिए ना, रिकॉर्ड्स चेक करिए दीजिए। Thereafter, the learned trial court observed that the principal dependents were also party in the partition suit number 24 of 1930, in which property was, the suit property was inter alia, the suit property was allotted in favor of the pro forma dependent number 4. The court observed that the court then referred to Exhibit 4 and then to Exhibit 3 series, which are the Chowkidari rent receipt of the village, showing that the plaintiffs were residing in village Bhavandi. It was also observed that one of the witnesses of the defendant, namely DT.05.12, had also admitted this fact and ultimately held that the plaintiffs were residing in village Bhavandi on plot number 254. The court further considered the oral evidence of PW1, 3 and 5, who were the witnesses on the point of possession, and observed that they have clearly stated that the plaintiffs was in possession and there was no cause to disbelieve their version. In the light of the documentary evidence and the admitted fact of the defendant. The court then considered the oral evidence of the defendants in support of their possession and observed that except oral evidence, they failed to prove their title and possession on the basis of documentary evidences. And observed that the oral evidence of the witnesses of the defendant cannot be accepted. The court ultimately held that merely on the basis of read receipts, the defendant cannot establish their adverse possession on the disputed land. And after considering the oral and documentary evidences and the attending circumstances of the case, and the admitted fact that pro forma defendant number 4 was the owner of the suit land, the court held that the plaintiffs have title and possession over the suit lands and decided the issue accordingly. And decided the issues in favor of the plaintiffs. With respect to issue number 1, 3 and 6, it was taken up together. All the issue number 1, 3 and 6 were decided in favor of the plaintiffs. However, with respect to court fees, the learned court was of the view that the court fees was deficit by rupees 1,500 and the plaintiff was to pay the deficit court fees. The court ultimately held that the plaintiff had valid cause of action and decreed the suit in favor of the plaintiff. The first appellate court at the first instance gave concurrent findings and dismissed the appeal. And ultimately the matter was taken up before this court in second appeal by the defendants, which was numbered as appeal from appellate decree number 66 of 1981. The second appeal was decided by judgment dated 18th of November 1988. The High Court in the second appeal observed that observed on the point of law that there was no escape from coming to the conclusion, observed in paragraph 7, that there was no escape from coming to the conclusion that in order to acquire a realty title on the basis of occupancy right thereon, under the state of Bihar in terms of section 6 of Bihar Land Reforms Act, a tenure holder must be in khas possession of the property on the date of vesting in question, within the meaning of section 2K of Bihar Land Reforms Act, to become a Rayat having occupancy right under the state of Bihar as contemplated under section 6 thereof. The court observed that unfortunately this aspect of the matter was not considered by the learned courts, and held in paragraph 12 that without in any manner held in paragraph number and held in paragraph 15 that a question arises for consideration as to whether, and if so, when pro forma dependent number 4 came in possession of the property forcibly or otherwise before the date of vesting of zamindari or not, and observed that the learned courts did not answer this question and ultimately remanded the matter to the first appellate court with the direction to give a finding as to whether the plaintiffs were entitled to a degree as paid for in view of the fact that Janak Rajkumar, within bracket pro forma dependent number 4, that includes, was in khas possession of the property in question on the date of vesting of zamindari in the state of Bihar or not, or she was otherwise entitled to a degree as against the defendants. It was also directed that the first appellate court shall consider the matter on the basis of the evidences available on record and without being prejudiced by any observation made by the court. Apparently, the order of remand by the learned first appellate court was a limited remand as to whether pro forma dependent number 4 was in khas possession of the sued property on the date of vesting, and whether she was otherwise entitled for a decree against the principal dependents. The learned first appellate court observed in paragraph 8 that the matter has been remanded on the limited point as to whether Janak Rajkumar, pro forma defendant number 4, was in khas possession of the property in the suit on the date of listing of the zamindari in the state of Bihar or not, or she was otherwise entitled to a decree as against the defendant appellants. Paragraph 8 of the appellate court judgment is quoted as under. Consequently, इसको 8 बार quote करिए. Consequently, the learned first appellate court framed the point for decision in the appeal upon remand as follows in paragraph 9, which is quoted as under. By considering the point number 1, the learned first appellate court upon remand and in the impugned judgment observed that the plaintiff that it was stated on behalf of the plaintiffs that the year of the relating khata number 116, 120, 121 and 122 had abandoned their holding, and therefore sued property in connection with these plots in these khata numbers came in possession of the pro forma defendant number 4. However, the court observed that in that connection, there was no mention of the year as to when the respective rayats abandoned their land, and there was no chit of paper to this effect. The court observed that besides observed that from the perusal of the final decree of partition suit number 24 of 1930 United Exhibit 6, Takta of pro forma defendant number 4 United Exhibit 7, it was clear that apart from the Rayati Khata number 116, 120, 121 and 122. The pro forma dependent number 4 was also allocated property in Khata number 88 and Khata number 89. I also observed that it was manifest that except the property, the suit property relating to Khata number 88 and Khata number 89, the other disputed property relating to Khata number 116, 120, 121 and 122 the same were in possession of not in possession of pro forma dependent number 4, rather they were in possession of the respective tenants. Thus, the first appellate court clearly observed that the Rayati Khata number 116, 120, the plots in Rayati Khata number 116, 120, 121 and 122 were not in possession of the pro forma dependent number 4, and there was no material to show that these properties were abandoned by the rayats. The court also observed that with respect to Khata number 116, 124, 121 and 122, in the return filed, the name of respective rayats was also mentioned in the remark column. And was thus clear that at the time of vesting of zamindari, rayats had not abandoned the land of the Khata number 116, 120, 121 and 122, and that pro forma dependent number 4 was not in possession of the suit property relating to the aforesaid 4 khatas. The court then observed that admittedly pro forma dependent number 4 had not filed any petition for assessment of rent in Form K under Section 5, 6 and 7 of Bihar Land Reforms Act of the land, as she never claimed to be those properties in her khas possession. The learned court thereafter referred to the registered CD dated 15/9/1962 executed by pro forma defendant number 4 in favor of the plaintiffs, and was of the view that and observed that in the recital of the sale deed, though pro forma defendant number 4 claimed that she came in possession of the suit land, but it was neither proved from Takta or partition (Exhibit 7) or even the return filed by pro forma defendant number 4 that the land of khata number 116, 120, 121 and 122 were in her khas possession. The learned first appellate court thereafter examined the oral evidences adduced. After having held that the documentary evidences filed on behalf of the plaintiffs did not suggest that pro forma defendant number 4 was in khas possession of the suit property with respect to khata number 116, 120, 121 and 122. The learned court proceeded to consider the oral evidence and observed that the plaintiff's witness PW1 had admitted that he never cultivated the suit land and could not speak about the possession of the plaintiffs or their vendor. PW4 and the court then discarded the evidence of the court then considered PW4, who was 36 years of age, who stated that he had no concern with the disputed land and stated that the house over the property was constructed about 20 years ago, that is in the year 1957. By the plaintiff, but the plaintiff never claimed to be in possession of the property prior to 1962. And further, the case of the plaintiff was that house was constructed by Janak Kumari Raj, pro forma dependent, and consequently observed that the evidence of PW4 was of no value. With respect to PW5, the court observed that he was not competent to depose on the point of possession because of his age, as to who was in possession of the property on the date of vesting. The court ultimately held, with respect to khata number 116, 120, 121 and 122, that the plaintiffs failed to prove either title or possession of pro forma dependent on the date of vesting of the intermediary interest with respect to the same property. The aforesaid finding was in relation to only a part of the suit property. With respect to the remaining part of the suit property, the finding commences from paragraph 14 of the appellate court judgment. which was relating to khata number 88 and khata number 89. ये ना 88 and 89.
Pertaining to plot number 210.
प्लॉट नंबर नहीं लिख रहे, सिर्फ खाता नंबर,
जी
क्योंकि शेड्यूल ऑलरेडी कोटेड,
जी
नहीं तो कंफ्यूजन होता। 88 and 89 का इतना है।
रेंट रिसीट में भी खाता नंबर ही दिया गया, प्लॉट नंबर कोई
ठीक जी।
With respect to खाता number 88 and 89, from paragraph 14 onwards, and the court referred to the partition decree in partition suit number 24 of 1930 written by the Exhibit 6. The partition sheet, that is Takta Exhibit 7 and Zamindari return Exhibit 4, and observed that the land was in possession of the pro forma defendant number 4 at the time of vesting of the state of The court also observed that the plea of the principal defendant was that the pro forma defendant number 4 had left the village Bhavandi in the year 1922 and settled in another village, Dabra, but observed that there was no evidence to that effect. And further observed that even if she had left the village, her right and title over the land in Bhavandi would not cease in view of the documentary evidence on the court. With this short finding with respect to the remaining land which was left after khata number, after recording finding with respect to khata number 116, 120, 121 and 122, the learned first appellate court held with respect to properties in khata number 88 and 89 that pro forma defendant number 4 was entitled for assessment of rent at least with respect to property in khata number 88 and 89 by observing that she was in khas possession of the same on the date of vesting of the intermediary interest in the state. And ultimately, recorded the finding with respect to both the parts of the suit property, that is khata number 88 and 89 on one hand and khata number 116, 120, 121 and 122 on other hand in paragraph 15 as follows. Thus, the learned first appellate court held that pro forma defendant number 4 was in khas possession with respect to property in khata number 88 and 89 at the time of vesting, and with respect to khata number 116, 120, 121 and 122, the court held that the pro forma defendant number 4 was not in khas possession of those property at the time of vesting. Consequently, the finding in connection with khata number 88 and 89 was in favor of pro forma defendant number 4 and hence was in favor of the plaintiffs. And the finding in connection with khata number 116 120, 121 and 122 was against the pro forma defendant number 4 and consequently against the plaintiff, and full stop. By deciding the second point, for determination, the learned first appellate court held that in view of the findings in connection with point number 1, the plaintiffs cannot derive any title by virtue of sale deed dated 15/9/1962 with respect to property in khata number 116, 120, 121 and 122. The learned court thereafter observed that thereafter referred to the assessment of rent in the year 1970. They observed that the plaintiff claimed to have filed a petition for assessment of rent by pro forma defendant number 4 it was not allowed by asserting that the case record were missing. And thereafter they had filed a petition for mutation, which was numbered as mutation case number 345 of 1970-71, but the same was rejected. And as the suit land was already assessed in AR case number 5 and 6,
Yeah, third year.
LLS was already assessed conveniently in the name of the dependents. However, during the course of hearing, it has been pointed out that the case number of AR case number 5 and 6 of 1961-62 has only been mentioned but there was other two cases, that is Exhibit D and D by 1, being case number 1169 of 1955-56 and 1168 of 1955-56, both relating to cover number 89. M roll in connection with which has been exhibited as Exhibit E and E/1, and the rent receipts as Exhibit C series. The court also observed that the assessment of rent also showed that the defendants were in possession of the suit land for more than 12 years. And the vendor of the plaintiffs, that is pro forma defendant number 4, had not filed any objection to the assessment of rent in favor of the defendants. It was also observed that the evidence adduced on behalf of the plaintiffs was also not satisfactory about their possession or the possession of their vendor. The learned court, the first appellate court, ultimately recorded a finding that the plaintiffs have failed to prove otherwise their title and possession over the land relating to Khata number 110, 120, 121 and 122. However, there was sufficient evidence, both documentary and oral, to show that pro forma defendant number 4 was in possession of plot number, in possession with respect to properties in Khata number 88, 88 and 89. By virtue of partition decree exhibit 6 and FATCA exhibit 7. And ultimately held that the plaintiffs, by purchase of their posted land through sale deed dated 15/9/1962, have come in possession of the said land and have also perfected their title and possession over the same. Thus, the learned first appellate court, by deciding the 2 points of determination as framed pursuant to the order passed by the learned in second appeal, in appeal from appellate decree number 66 of 1981 (R), held that the defendant number, pro forma defendant number 4 was not in possession with respect to the properties in Khata number 88 and 89, and that, and also on the date of vesting, and also that the defendants, the principal defendants had perfected their title with respect to the said property by virtue of adverse possession.
नहीं एडवर्स पोजीशन नहीं बोले, एडवर्स पोजीशन नहीं बोले, परफेक्टेड टाइटल खाली बोले. The assessment of rent also show that petitioner defendants appellants were in possession of the suit land for more than 12 years. There is differences between the possession and adverse possession also.
Just a minute. उसके ऊपर देखिए,
इसी के ऊपर
उसके ऊपर. The assessment of rent also shows
petitioner defendants appellant in possession of the suit land for more than 12 years.
yes.
It does not mean adverse possession also. Let me complete. There are differences between the possession and adverse possession. Possession means possession of the property, and so far as the adverse possession is concerned, the non-owner lordship gain the ownership lordship to the knowledge of the real owner's lordship. Therefore, mere possession of 12 years it cannot be said to be adverse possession lordship. And this observation has been made 2004, 10 SSC page 779 para 11 lordship.
And thus perfected their title.
Yes. Perfected title means cannot be said to be adverse possession. There are several ingredients of adverse possession, lordship. May kindly judgment I have cited before this honorable court.
अच्छा एडवर्स मत, ठीक है, तो फाइंडिंग अ वे
जी.
and thus perfected their title and possession over the sea. Consequently, both the plaintiffs and the principal defendants became aggrieved by the impugned judgment by the First Appellate Court, and consequently, aforesaid two second appeals have been filed, which have been admitted by framing two different substantial questions as indicated. In view of the order of remand, scope of the order of remand passed in appeal from appellate decree number 66 of 1981-82. The crucial question is as to whether pro forma defendant number 4 was in possession of the suit property on the date of vesting. And the cut-off date, that is the date of vesting, is 25/1/1955.
Twenty-five 9/90/50.
25/9/50. 55.
25/9/1950.
1955 पूरे ऑर्डर में 1955 लिखा हुआ है।
मेरे में लगता मिसप्रिंट है।
नहीं, उसका थोड़ी होगा, वो तो हर एक जगह का अलग अलग है।
अलग अलग
1955 कर लो। This court finds that so far as the property in there can be no dispute that it is for the plaintiff to establish his case, and any lacuna in the case of the defendants will not give any advantage to the plaintiff. So essentially, it is for the plaintiff to establish that on the date of vesting, pro forma defendant number 4 was in possession of the suit property. This court finds that the possession is to be examined both in the light of oral as well as documentary evidences, which have been used. This court finds that the entire suit property is in two parts. One is relating to khata number 116, 120, 121 and 122. And the other is relating to khata number 88 and 89. This court also finds that the learned First Appellate Court has considered the evidences placed in the court, both oral and documentary, while considering the possession with respect to khata number 116, 120, 121 and 122 on the date of vesting. And on the basis of documentary evidences has, including the return filed by pro forma defendant number 4, has recorded that as per the return itself, she had shown that the property in khata number 116, 120, 121 and 122 were in possession of rents. Thus, essentially, she admitted that she was not in possession of the property with respect to khata number 116, 120, 121 and 122. The pro forma dependent number 4 had also filed a separate written statement. इसको जरा ध्यान से सुनिए. Had also filed a separate written statement before the learned trial court. And had taken a plea that the defendant number 4 was in exclusive and peaceful possession, as usual came to cultivate the land had also taken a stand that the radiates of khata number 116, 120, 121 and 122 had abandoned their holding and she came in possession and was cultivating the same after the recorded radiate abandoned the same. But such stand of dependent number 4 is contrary to her return, which was filed on the date of vesting. Further, no evidence has been pointed out by the legal counsel appearing on behalf of the plaintiffs, either oral or documentary, that which could reveal that the pro forma dependent number 4 that could reveal that the radiates had abandoned the property with respect to aforesaid 4 khatas, and the pro forma dependent number 4 had commenced cultivation on the same. ऐसा तो कोई evidence नहीं है. During the course of hearing also, during the course of dictation also, a specific question has been put to the learned counsel for the plaintiff.
इसको छोड़ दिया जाए, आप अपना रिजर्वेशन ले लीजिए.
ठीक है. This court finds that it was never the case of the parties, of the plaintiffs and the pro forma dependent, that anything was incorrectly recorded in the return. In view of this court also finds that apart from the aforesaid position The learned first appellate court has also considered the oral evidences placed on record and has ultimately come to a finding that Khata number 116, 120, 121 and 122 was not in possession of the pro forma dependent number 4 on the date of vesting. And it was, on the date of vesting, on her own showing, it was in the possession of the debtors. In view of the Section 6 of the Bihar Land Reforms Act, like Bihar Land Reforms. वहाँ के अंदर
इसको दे
specific references have been made to Section 2A and Section 6 of the Bihar Land Reforms Act with respect to the consequence of possession of intermediary on the date of vesting. And for that purpose, reference has been made to the judgment passed by Honorable Supreme Court
77
in the case reported in 77.
Guru Saran Singh case.
AIR 1977.
Guru Sharan Singh. In the judgment reported in bracket 1976 bracket close 2 SCC 152.
Given paragraph 21 and 22.
Paragraph 21 and 22. Which is quoted as under. And it has been this judgment has been relied by the learned counsel for both the parties.
Yes, yes.
The learned counsel for the plaintiff has relied upon this document to submit that a trespasser will not have any right over the property.
And the contesting defendant is neither the proprietor nor the tenure holder.
And the contesting defendant is neither the proprietor
Nor the tenure
nor the tenure holder. And even in the return, the name of the contesting defendant as variant has not been mentioned. इनका नाम तो नहीं है
नहीं
variant.
दूसरे लोगों का नाम.
On the other hand, it is the case of the defendants that the claim of the plaintiff would depend upon the physical possession of the property on the date of vesting. If pro forma dependent number 4 was not in physical possession of the property on the date of vesting. The plaintiffs, she cannot transfer any title, any valid title in favor of the plaintiffs, and consequently, the plaintiffs has failed to prove their case. Correct? यही आता. He has also submitted that the plaintiff has to stand on its own leg. कोई फाइंडिंग तो नहीं है कि आपका प्रॉपर्टी,
इनका फाइंडिंग्स नहीं,
ऐसा कोई फाइंडिंग नहीं
कोई
that the
finding.
property belongs to the defendants, ऐसा तो नहीं है.
कोई फाइंडिंग्स नहीं, दोनों कोर्ट को कोई फाइंडिंग्स नहीं.
हाँ. After going through the aforesaid judgment passed in the case of Gurucharan Singh, this court finds that in order to claim, read with the provisions of section 2K and section 6 of the Bihar Land Reforms Act, this court finds that
Section 6 is relates to lease and mortgage.
that's section 6. This court finds that the law is well settled that khas possession on the date of vesting essentially relates to physical possession over the property or physical control or occupation of the property.
And
Yes.
one more prior lordship. So far as other plot is concerned, they were assessed.
We'll come to the other plots का तो अभी कहानी नहीं बता
जी,
रहे. अभी उसकी कहानी बता रहे जिसका आपने रिटर्न फाइल
जी.
किया. Further, the case has to be seen in the light of the order of remand. In view of the aforesaid facts and circumstances and the aforesaid judgment passed in the case of Gurucharan Singh, this court is of the considered view that the plaintiffs and consequently the pro forma defendant number 4, उनकी तरफ से तो कोई एविडेंस नहीं दी हुआ.
प्लेंटिव की तरफ से
Pro forma
नहीं,
defendant number 4,
परफॉर्मा डिपेंडेंट फोर्स की तरफ से.
who did not even need any evidence before the learned court. Cross examination नहीं हुआ.
नहीं, जब किए ही नहीं है.
नहीं,
नहीं,
WS तो फाइल की है.
फाइल ना.
जो सर किया लेकिन एविडेंस के लिए फिर नहीं.
But there has been no separate cross examination on her behalf before the learned court. There can be no doubt that pro forma defendant number 4 was not in possession of the property relating to khata number 161, 120, 121 and 122
जी.
on the date of vesting. And therefore, she could not have passed any good title in connection with the property in the said khatas in favor of the plaintiffs. the finding of the learned first appellate court in connection with plot number with khata number 116, 120, 121 and 122 does not fall under the interference. Consequently, the substantial question of law as framed by this court in
Second appeal number 69 of 1991.
second appeal number 69 of 1991 is answered in favor of the defendant, principal defendants and against the plaintiffs by holding that the judgment of the learned first appellate court allowing the appeal with respect of plot number 144, khata number 116, plot number 151, khata number 120, plot number 623 and 749, khata number 121 and plot number 251 of khata number 122 of village Bhavandi is based on evidence and the findings cannot be said to be false. दूसरा next part. So far as the findings of the learned first appellate court in relation to the remaining property of khata number 88 and 89 is concerned, which is subject matter of उसमें लिख लीजिएगा accordingly essay number 69 of 1991 with divided R is dismissed. So far as the finding of the learned first appellate court with respect to the remaining property in khata number 88 and 89 are concerned, which is subject matter of second appeal number 58 of 1991 with bracket R, filed by the
Defendants contesting
defendants, by the principal defendants is concerned. This court finds that the learned first appellate court, by recording the finding in paragraph 14, has not at all considered the oral evidences based on the record. The finding in paragraph 14 of the appellate court's judgment is quoted as under. This court also finds that the pro forma defendant number 4 in her return had admittedly shown these properties to be in her possession on the date of this. Yeah. This court further finds that in the assessment of rent in case number 1169 of 1955-56, case number 1168 of 1955-56, and suo motu case number 5, Roman 5 and Roman 6 of 1961-62 the property relating to plot number 254 does not find mention. However, during the court, when this was pointed out to the learned counsel appearing on behalf of the principal defendants, he has stated that since a house stands on the same property, therefore, the same does not find place in the aforesaid cases relating to assessment of rent. इस पर आप क्या बोलना है?
हाउस का भी तो रेंट एसेस होता ही है.
To this, the learned counsel for the plaintiff has stated that even for the land on which the house stands, the rent is assessed.
Assessed.
The fact also remains that it is essentially for the plaintiff to prove that pro forma defendant number 4 was in physical and actual possession of the property relating to खाता number 88 and 80. इसमें तो कोई डाउट नहीं.
नहीं, डाउट है ना.
प्रूफ तो आप ही को करना है ना.
तख्ताबंदी जो हमको अलॉट हुआ है उसी से प्रूव हो रहा है कि हम पोजीशन में है.
बस 1930 तक आप पोजीशन में यहाँ कहाँ डिस्प्यूट?
नहीं, कोई डिस्प्यूट नहीं है.
On the date of listing.
62 में 62 तक तो हम सेल किए हैं, परचेज किए हैं. और जो तख्ताबंदी मेरे फेवर हुआ इसका मतलब है कि हम पोजीशन में थे लैंड.
वो तो आप पूरा ही सेल कर दिए.
हाँ, पूरा ही कर
पोजीशन में ही नहीं
दिया.
थे.
हाँ, पूरा ही कर दिया, वो तो ठीक है. मगर जो हमको तख्ताबंदी हुआ है, whether I am possession or not, which is immaterial lordship. The Janak Kumar acquired the land by virtue of partition suit and suit property allotted to Janak Kumar. Therefore, it is proved that I am the possession of the land. And there is also no provision in Bihar Land Reforms Act to initiate a sumo motu proceeding for assessment of rents.
That's- In the aforesaid background, the Uh, the fact also remains that the plaintiff, the pro forma defendant number 4 had transferred had inter alia transferred properties in khata number 88 and 89 to the plaintiffs by virtue of registered sale deed, which has never been challenged by the defendants so far.
Yes.
In this is a real
Just a moment. With respect to the possession on the point of vesting, the oral evidence adduced on behalf of the parties assumes much relevance. So far as PW1 is concerned, he has stated that PW1 has stated that the dispute property is in possession of the plaintiffs, and prior to that, it belonged to pro forma defendant number 4. However, during his cross-examination, he has stated that pro forma defendant number 4 was living in Dublin. Which is a separate village. PW1 is the age with time. The PW1 has not made any separate statement in connection with the property in khata number 88 and 89. Rather, PW1 has made the statement in connection with the entire suit property. PW2 has not stated anything in connection with the possession of the suit. Correct? So far as PW3 is concerned, आपके पास है ना सारे डॉक्यूमेंट्स लीजिए बस. He has also not stated anything in connection with the possession of the suit. So far as PW4 is concerned, he claims to be 36 years of age as on 21/2/1980. So 55 में इनका कितना एज था? Therefore, on the date of vesting, he was around 14 to 15 years of age.
14 to
14 to 15 years of age. And he has stated that he has seen the plaintiffs cultivating the property for last 17 to 18 years. And he has also stated that over the property there is house of the plaintiffs in which they are living. Here, during his cross-examination, he has stated that the plaintiffs are has stated that the house over the, and he has stated that he is not able to give the khata number and plot number and boundary of the properties. And he has also stated that the house on which on the house the plaintiffs are living in which has been constructed by America Ram around 20 years back. And he has also stated that at the time of construction of house, he was 14 to 15 years of age.
PW3 बोले हैं कि पोजीशन में है इसमें। PW3 बोले हैं कि पोजीशन में है।
PW3
जी।
अभी तो कुछ भी नहीं बोली।
पढ़ देते हैं। मैं इस मुकदमा के दोनों
कौन है PW3?
PW3
PW3 कहाँ बोले पोजीशन?
बोले मेरे पास
कहाँ है?
मैं इस मुकदमे के दोनों पक्षों को जानता हूँ। तकरारी जमीन को भी जानता हूँ। तकरारी जमीन लगभग 6 एकड़ है। यह जमीन अमेरिका राम तथा निर्मल राम की दखल में है। Oh, PW4, sorry. PW4.
PW3 कुछ नहीं बोला, एक लाइन
No,
बोला।
sorry, I'm sorry.
हाँ।
PW4.
This court finds that it was a specific case of the pro forma defendant number 4 that she was living in the said house and PW4 has stated that the house was constructed by क्या नाम है इसका अमेरिका राम
लिखे हैं
Around-
कि जमीन अमेरिका राम तथा निर्मल राम
That's
की
right.
दखल कर
वो
में
है।
है। हमें इसका जोत
आप
आबाद है 17-18
कंफ्यूज मत करिए प्लीज He has specifically stated in his cross examination that America Ram had constructed the house around 20 years back.
नहीं, जमीन जोत भी करते हैं, भी लिखे हैं।
20 years back.
हाँ,
घर के बारे में बात
नहीं, हम पढ़ देते हैं,
Actually, court have judged that
हम पढ़ देते हैं लोग।
Venturam never claimed that before 1960s.
नहीं, हम एविडेंस से पढ़ दे रहे हैं।
67 of
एक मिनट। मैं इस मुकदमे के दोनों पक्षों को जानता हूँ, तकरारी जमीन भी जानता हूँ। तकरारी जमीन लगभग 6 एकड़ है। यह जमीन अमेरिका राम तथा निर्मल राम के दखल में है। मैं उनका जोत आबाद 17-18 वर्षों से देख रेख कर रहा हूँ। तकरारी जमीन पर नगीना राम या नरेश राम का जोत आबाद नहीं देखा है। डिपेंडेंट का प्रिंसिपल डिपेंडेंट के बारे में
Yes.
आप रुकिए ना।
He has stated that he has been looking after the cultivation of the property
Yes,
for last 17 to
18 years
18 years and he had not seen the dependents cultivating. the
cultivating.
And he has also stated that the house was constructed by America Ram around 20 years back.
जी,
This witness has deposed on 21st February 1980. And he was 36 years of age as per his own declaration and recorded in the evidence. And further, he has got no idea about the area, plot number, etc. with respect to the street. This witness is not a competent witness with respect to the possession of the suit property on the date of vesting. This court finds that the evidence of this witness is also not specific in connection with one or the other plot numbers of the suit property. The learned First Appellate Court has rejected the evidence of this witness by observing that he had stated that the house was constructed on the property around 20 years back, that is sometimes in the year 1957 by Ambika Ram. Although Ambika Ram never claimed that the land before 1962. And further, the plaintiffs claim that the house was constructed by pro forma defendant number 4. This court is of the view that the learned First Appellate Court has rightly made the observation in connection with PW4, and since PW4 has not made specific statement in connection with one or the other suit plot, therefore this court is of the view that the evidence of PW4 also does not help the plaintiffs when it comes to the plots in cover number 88 and 89 are concerned. PW5 is another witness. Who is the plaintiff number 2? He himself in his cross-examination has stated that gained Hosh within bracket consciousness sometimes in the year 1958. He is 35 years of age on the date of examination on 21st of February 1980. On 12 to 1980. The learned First Appellate Court has recorded with respect to his evidence that he is not the competent witness to say as to who was in possession of the property on the date of vesting of the eligibility interest. As this witness was only how much? What was his age? 15 years. That should be sufficient. This court finds that this witness has also not made any specific statement in connection with one or the other suit plot, and his evidence is relating to the entire suit property. This court is of the view that this court is also of the considered view that PW5 is not a competent witness to say as to who was in possession of the suit property as in the year as on the date of vesting. ये PW4 का मनी है, कुछ डेट है?
नहीं, डेट नहीं।
और कोई नहीं, PW6
तहसीलदार के हैं।
इससे क्या डिराइव करेंगे?
इसमें तो ये बोल रहे हैं कि तीनों चौकीदारी की रसीदें
पोजीशन के बारे में तो कुछ नहीं बोला।
लिखी है। चौकीदारी रसीद जब कब कटता है, जब पोजीशन
He has not stated anything about possession.
ये बोले हैं कि मेरे हस्ताक्षर से हुआ है।
So far as PW6 is concerned, he is the Tehsildar. He has simply identified the Chowkidari rent receipt. He has not stated anything with respect to possession of the suit property, physical possession of the suit property on the date of listing. So far as the evidence of PW8 is concerned, the same also has no relevance with respect to the possession of the suit property. This court also finds that although PW4 had filed written statement, she would have been the best witness to come forward and depose on the point of her possession. But after filing of written statement, it appears that she did not participate in the trial at all. And has not led any evidence before the London court. However, the cross-examination is not specific in connection with however, the witnesses have been cross-examined, witnesses of the defendants have been the principal defendants have been cross-examined, but it is not clear as to at whose instance the cross-examination has taken place. So far as the witnesses on behalf of the defendants are concerned, this court finds that defendant witness number 1, 2 and 3 have not stated anything on the point of possession. So far as DW4 is concerned, he is 51 years of age on 12/3/1980. And he has stated that prior to he gained consciousness, the pro forma defendant number 4 was not residing in village Bhavani, but was residing in another village called Dabra. And he has also deposed that the principal defendants were in cultivating possession of the suit property since he gained consciousness. They were cultivating the property. However, no specific date with respect to the possession of the defendants has been given by defendant number 4. During his cross-examination, he has stated that principal defendants have been cultivating the property for last 25 to 30 years. But he was unable to give the exact year. He has also stated during cross-examination that he had not seen the plaintiffs residing in village Bhavandi, but they were residing in Daltonganj, but he did not know their exact location. DW5 who was 53 years of age as on 13th March 1980 has stated that the husband and the son of pro forma defendant number 4 had expired much prior he gained consciousness, and defendant number 4 had never stayed in village Bhavandi and was living in another village, namely Dabra. He has also stated that the rent was fixed in favor of the pro forma defendant number 4. Rent was was not fixed in the name of pro forma dependent number 4, rather the rent was fixed in the name of the principal dependents. And pro forma dependent number 4 never filed any case seeking eviction of the principal dependents from the suit property. During his cross-examination, he has stated that the principal dependents have been paying rent since 1955-56. However, he is not aware as to whether principal dependents have filed any zamindari return. And he has also stated that the suit property is adjoining to his property and has given the details of his own property as khata number 125, plot number 140, area 10 December. Defendant number 6, witness number 6 and 7 on behalf of the dependents are not relevant so far as the point of physical possession of the property is concerned. DW8 claims to be the Purohit of the husband of the pro forma dependent number 4 and has stated that pro forma dependent number 4 never stayed in Bhavandi and she had no house in Bhavandi. However, he has stated that the principal dependents were in possession of the suit property for last 15 to 16 years. And during cross-examination, he has stated that he was working as a Purohit for only 15 years. And he was not even aware of the name of the husband of the dependent number 4. Although in his chief he stated that he was the Purohit of Vishweshwar Dayal Singh, who was admittedly the husband of dependent number 4. Correct? DW9 is 51 years of age on the date of deposition, and he had a plot in village Bhavandi which was adjoining to the plot number 144, which is the suit property, which is one of the suit property involved in this case. And he has stated that the entire property remained in possession of dependents right since he gained consciousness. He has also stated that pro forma dependent number 4 never stayed in Bhavandi and pro forma dependent number 4 never cultivated the suit property. He has also exhibited certain rent receipts. He has been cross-examined and he has he has stated that around 10 kathas are dhan and the remaining are tar khet. Dhan khet and the remaining are tar. He is not aware as to whether there is a house on plot number 254. He has stated that he gained consciousness in the year 1938-39 and since then he knew and has also stated that he knew the plaintiff for last 20 years and it is not correct to say that the plaintiffs are living on plot number 254. He has also stated that during cross-examination that each principal dependent is cultivating the land in different portions. DW10, who was 70 years of age on the date of deposition on 15th of March 1980, has also supported the case and he had seen the son and husband of the pro forma dependent number 4 and has categorically stated that dependent number 4 left Bhavandi Mauza and never came back. And he had further stated that the principal dependents were cultivating the property and he had never seen the plaintiffs in possession of the property. During cross-examination, he has stated that he knew America Ram, one of the plaintiffs, and who got married sometimes 30 years back. he has also stated that he was, during cross-examination, that he was working in the house of the pro forma defendant number 4, but had no concern with agricultural land. He has given the name of the husband of defendant number 4 as Vishweshwar Dayal Singh during cross-examination, and had no idea as to how much land pro forma defendant number 4 had in village Bhavandi. He has stated that pro forma defendant number 4 had cultivation in Bhavandi, but after the death of her husband, she left Bhavandi and never came back. DT.05.12.2025 has also supported the has stated that Vishweshwar Dayal Singh, the husband of the DW4, had expired before he gained consciousness, and he used to call defendant number 4 as Dadi, who used to live in Dabra. He has stated that she never lived in Bhavandi from the date he gained consciousness, and she was never involved in cultivation. And he has also stated that the fruit property was being cultivated by his brothers and grandfather, and they were also paying rent. And stated that the plaintiffs Nirmal Ram and America Ram were never in possession of the suit property. And even on the date of vesting, the principal dependents were in possession of the suit property, and the pro forma dependent number 4 did not take any steps to evict the principal dependents. This court finds that the defendant witnesses have fully supported the case of the principal dependents, and upon perusal of their evidence, it is clear that, and they have consistently deposed that after death of husband, principal dependent number 4 left Bhiwandi and started living in another place called Dabra. There is consistent evidence from the side of the dependents that principal dependent number 4 was not in possession of the properties, suit properties, on the date of vesting. This court finds that the learned first appellate court, by considering the properties in relation to Khata number 89 and
88.
88, has not referred to the evidence of the witnesses at all. However, upon consideration of the evidences on record, this court is of the view that, on the one hand, the plaintiffs, through oral evidence, have not been able to prove that defendant number 4 was in physical possession of the suit property of the apostate Khata number 88 and 89 on the date of vesting. And on the other hand, the defendants have been able to prove that it was the defendants who were in possession of the said properties. This court also finds that there is no reason ascertainable from the records as to why the defendant number 4 did not depose before the court. Who could have been the best, who could have been the best oral evidence on the point of possession with respect to the suit property. In view of the aforesaid findings, this court is
One more. Suo motu rent receipt was
rent
initiated.
receipt पे तो हम जा ही नहीं रहे. Nothing required. Defendants, I'm just discussing the oral evidence
With respect to the position.
with respect to the possession. Because possession on the date of vesting is the only issue after the order of demand. Admittedly, the rent was never assessed in favor of the pro forma defendant. And rent receipts have been issued in favor of the principal defendants in two cases, and remaining has been assessed in their favor by the state by suo motu.
In Bihar Land Reforms Act 1950, there is no provision to initiate a suo motu proceeding
That's right.
for assessment of rents.
A strong objection has been raised by the counsel for the plaintiff that there is no concept of assessment of rent on the basis of suo motu. But it appears that the rent was assessed primarily on the basis of physical possession of the property. However, considering the order of demand and considering the scope of the substantial question of law as framed by this court, this court finds that the learned first appellate court has committed perversity by not referring to the oral and documentary evidences based on record with respect to the properties in Khata number 88 and Khata number 89, and upon consideration of the oral evidences and upon consideration of the materials, this court finds that the plaintiffs have miserably failed to prove their possession, much less the possession of pro forma defendant number 4 over the suit property on the date of vesting. Accordingly, the substantial question of law framed in second appeal number 58 of 1991 is answered in favor of the appellants who are the defendants, contesting defendants before this court, and against the plaintiffs. Second appeal number 58 of 1991 is accordingly allowed, and second appeal number 69
69.
is dismissed.
Okay.
58 is allowed, submission, progress made. 58 is allowed.
Yes.
And 69 is. थोड़ा लेट से बैठे